Everybody say, ah, oh, say, how can I express
my gratitude
for all the many things?
all the many things you've done for me?
Words are not enough, yeah.
Enough to say thank you.
Say, Lord, you are my everything.
You're
Mama,
my
Jane.
everything.
How can I express my gratitude
How can I express my gratitude
for all the many things,
all the many things you've done
Father, you
for
done
me?
for me, yeah.
Words are not enough to say thank you.
Say, Lord, you are,
Lord,
you
you're
are.
my
Say,
everything.
I call you
call you
Jireh.
Jireh. You're my
I
provider.
call you Nisi.
Nisi.
You are my battle.
My back.
I call you Rapha.
call you Rapha.
Hey.
You are my healer.
Say, Lord, you are.
Lord, you're my everything.
I call you Jireh.
call you Jireh. You're my provider.
I call you Nisi.
Nisi.
You are my banner.
My back.
I call you Rapha.
call you Rapha. You are my healer.
Say, Lord, you are.
Lord,
You are.
you're my everything.
Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah. So, uya.
Moya matinina. Moya matinina.
Yeah.
Moya matinina.
Oh,
Moya matinina.
say, I call you Jireh, say,
I call you
yeah.
Lord, my provider.
I call you Nisi.
Nisi.
You are my battle.
My back.
I call you Rapha.
call you Rapha.
Hey.
You are my healer.
Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. Will you make one cover? What to say?
Oya mi kwako kila mabani. Menina so.
Yeah. I can breathe without you, say. I can move without you, Lord. Hey. Who am I without you? Say, I can live without you, yeah. I can breathe without you, Lord. I can move without you, yeah. Who am I? Who am I? Who am I? Who am I? Hey. Who am I thinking now? Oh.
Welcome once again to another edition of the Community and the Law. My name is Eunice Echampon, and for today I will be your host. I am not the guest for today, I am your host for today. And so, Happy New Year to all of our viewers watching us on Facebook and YouTube. We are very, very grateful to have your support. Please like and share the program and comment as well as ask your questions. If you do have any questions, please do make sure you leave them in the comment section, or you can phone later on during the program to have your questions answered. We thank you once again for joining us for the community and the law, and we'll very soon introduce our guest for today. However, we'll briefly hear from her, and we'll have some updates later on as well. And then we'll look at our nuggets for this week. We've also introduced this year something very interesting to make it interactive with our viewers. We have Know Your Rights. And we know when it comes to immigration law, there are so many things that keep coming up, and we want to make sure that our viewers are aware of the law and that they are ready to use the law to benefit them one way or the other. And so we will also be sharing with you this week's Know Your Rights as well. And without much ado, I would like to introduce our guest for today, Miss Annie Akofio Soa.
Hello, good morning to all our viewers and listeners. Good morning, Lawyer Eunice. How are you?
I'm doing well. I know that it's seeming like morning, but it's
Oh,
already
good
4
afternoon. Yes.
p.m.
Oh dear.
So yes, thank you so much for joining us today, Annie. And I know that the program is going to be a delightful one, having us two ladies on the program together. Please, 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 to our viewers, please make sure that you share and you like the program as well. Okay, we'll take a very, very short break and then we'll come back with our nuggets for this week and know your rights.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345. Or you can send a text 07950 422780. It's The Community and the Law. My name is Oreku Frimpon and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you once again for joining us on the community and the law. So, as I previously said, we will be looking at this week's nuggets, and then obviously we'll be looking at some updates that we have for the week. But first of all, we would like to introduce you to our new, should I say, trial for the community, which is knowing your rights. So we have here demystifying the UK immigration law. So we are welcoming all our viewers to now know their rights as within immigration law. And immigration law is a very, very vital part of our society, because most of us, one way or the other, have migrated from one country into the UK and have made the UK our home. So immigration law is vital for anyone who wants to work or study or reunite with any family member or seek asylum in the UK. It provides the framework for who can enter, stay, or leave the country. And it ensures that individuals know their rights at every stage, at every point in time. You know whether you have leave to stay, whether you have no leave to stay, and how you can remain in the UK if you find that you do not have leave to remain in the United Kingdom. Also, with immigration law, there are different categories as well. And so it's also very important that as much as possible, we keep up to date with the different categories that we have under immigration law. So we have work visas, which is for skilled workers, other professionals, innovators, temporary workers, seasonal workers. So the work visa route is for these kind of people. And then we also have study visas. These are for international students who want to pursue education in the UK from the age of 4 onwards. So study visas are for students who want to come to the UK to educate themselves. And then we have the family visa route, which is for people who want to join their partners or children or parents here in the UK. That is the family visa route. And then we also have the asylum applications route, which is to protect those who are fleeing persecutions from their home country and therefore are seeking asylum in the UK. So, as the weeks go on during the year, we will be making sure that as much as possible we are keeping you updated because we know that immigration law affects thousands of individuals and families every year. And so, as much as possible, we want our viewers to stay compliant with the UK regulations. We want them to avoid unnecessary delays or denials, and we want to make sure that they are informed of their choices regarding their immigration status. You do not want to be caught up in a situation where you are not sure what your immigration status is. So we'll be doing this every week. So join us each week as we explore these categories in detail, offering you practical tips and expert advice to make sure that your immigration journey is much smoother. So, if you're planning as well to come to the UK, please do make sure that you contact any member of our team for advice and assistance. Our contact details are as on the screen. Our UK office number is 0208 493 7340. Our Ghana office number is 00233 555895959. And in emergencies, you can phone 077 127 61884. And our website is also clearly shown on the screen. So do take note of these contact details so that you are not left behind. So yes, when it comes to our updates, a lot of us will be aware that the current government that we have is making sure that they take steps to make sure that those who have said they would employ people from outside of the UK stay compliant with the immigration rules. So any employer or any sponsor who has decided to employ somebody outside of the UK would usually have had a sponsor license given to them by the UK government or the Home Office. And there are rules or there are regulations that they have to comply with. And therefore, as you can see on your screen, the Home Office has made an announcement that they will take strong action against employers who do not comply with the rules. Where necessary, they will revoke their sponsor license. And they will strengthen this by making it harder for those with a long-term record of non-compliance to return to the sponsor register. So if you are an employer and they find out that you keep flouting the rules, you are constantly bringing in workers, but there is no work for them to do, or you are, for one reason or the other, taking certain charges from them, they are more likely to revoke your license and make sure that you are never put on the sponsor license register ever again. Currently, employers who flagrantry flout visa rules can only be sanctioned for a maximum of 12 months. And the new changes, they intend that the period for repeat offenses will be at least 2 years, double the current length, with final cooling off periods announced in due course. So currently, if the Home Office finds out that you are an employer who is currently taking on employees without work and you are flouting the immigration regulations, they will make sure that once your license has been revoked, you will have to wait for 2 years before you can try to apply again. And so we want to make sure that those who are employing people from outside of the UK are keeping hold of the rules in place so that they are not caught off guard. And so the Home Office statement sets out the companies who will be prohibited from passing on to migrant workers the cost of sponsoring them. In her statement, which is Seema Malhotra, who is one of the ministers for the UKVI, she explains that businesses recruiting internationally will be required to pay for certificates of sponsorship. sponsor licenses, and associated administrative costs themselves and not to pass it on to the employees. If you are found out to be passing on the cost to the migrants who are coming into the UK to work, that will also be a breach of your regulations as an employer. And so they are making this very clear that any employer who is seen to be charging the migrants will be breaking their rules. It should be noted that it is already contrary to the immigration rules and the guidance to require a worker to pay certain fees. And therefore, this has been made very clear in their guidance for sponsors and their sponsor duties and compliance guidance as well. So I hope that our employers who are currently with sponsor license and are bringing in employees from outside of the UK will take note of this. And when it comes to the government's intention, they wish to consider that immigration compliance goes alongside with employment law requirements. So most employers will already be under employers employment obligations, and therefore the government has also stated that they will be bringing in a new employment rights bill. They already have the Employment Rights Act of 2006, but they will be bringing in a new employment rights bill to make sure that employers are complying with the rules. And so the government has made sure that the changes fall in line with the bill, which will be introduced and passed through Parliament. Under this employment rights bill, the newly established Fair Work Agency will bring together existing state enforcement functions, including regulations for employment agencies and employment businesses, enforcement of the national minimum wage, enforcement of statutory sick pay, and the licensing regime for businesses operating as gangmasters in certain sectors. So it is very important that those employers who have obligations under the Employment Rights Act will also make sure that with this new Employment Rights Bill, which will be very soon enacted through Parliament, will also make sure that they are making their rules fall in line with the national minimum wage, statutory sick pay, and then licensing regimes for businesses as well. So it's important that if a company is running without these regulations, they make sure that they are up to date with these regulations. Given this approach, it is important for sponsors to ensure they are complying with their sponsor duties in preparation for potential compliance checks and visits. In this regard, sponsors may wish to consider arranging an immigration audit with our specialist team at BWF Solicitors, and this will help you prevent any non compliance issues later on in the future. We have put again our contact details if the need arises that you contact us. Okay. We have here one of our clients who has given good feedback. She says BWF helped me overcome a tough time and to reunite with my family and to secure my indefinite leave to remain. Their support and teamwork are outstanding. Thank you so much, Gift to HR and team. We do look forward to working with you again. And if you have any recommendations, we do look forward to working with them as well. Okay, so without wasting much time, we'll look at our nuggets for this week. So it says the courts have said that in some cases, harassment may be caused when the harasser is not motivated by the protected characteristic as defined by law. This breach of the law may happen if the comments are unwanted and reasonably have the purpose of or effect of violating dignity, then they can amount to harassment. The fact that the comments made were not motivated by the claimant's race did not prevent them from amounting to harassment if the other parts of the definition of harassment were also met. This is as in the case of E. Carosi and the University of Hertfordshire, Miss A. Lucas, 2024, Employment Tribunal 169. So, I know that our guest for today, Miss Annie Akofio-Sowa, is going to take us through the nugget for this week, and then we'll have a quiz question at the end of the program.
Thank you, Lawyer Eunice. So, yes, the nugget for this week is concerning comments about an employee's accent. And we have learned that it can amount to harassment in certain circumstances. So, the case law that we particularly looked at is the case of E. Garosi and the University of Hertfordshire 2024. So, just to provide background information, this case was concerning an employee. Her name was Elaine Garosi, and she was working with the University of Hertfordshire as a marketing engagement and partnership manager. And she was she was a Brazilian. So her employer at some point said that her accent is quite strong and that they were not able to understand her quite well. So later on, she resigned and she basically took the matter to the employment tribunal, where she had three claims. So she claimed victimization, harassment, and discrimination. And when she took the matter to the employment tribunal, it was held that her claim of harassment would fail because the comments that were made by her employer were not necessarily in relation to a protected characteristic. However, she didn't stop there. She then took the matter to the Employment Appeal Tribunal, which held that the comments that were passed by her employer could indeed amount to harassment. So, what is harassment? Section 26, subsection 1 of the Equality Act 2010 basically defines what harassment is or what type of conduct would amount to harassment. And it says that the conduct of person A towards person B would amount to harassment if number one, the conduct is unwanted. Number two, it is in relation to a protected characteristic. Number three, it results in violating B's dignity, or four, it creates an intimidating, hostile, degrading, humiliating environment for B. So the Equality Act 2010 sets out characteristics, also known as protected characteristics, which you cannot discriminate an employee against. So some of them include, for example, a person's age, their race, if they have any type of disability, their sexual orientation, their gender. So you're not allowed to discriminate against someone based on these protected characteristics that I've just gone through. So when the claimant here in this case, Elaine Carosi, took the matter to the Employment Appeal Tribunal, it was held that the comments that her employer passed did amount to harassment because it met the definition of harassment. The comments that were passed were concerning her accent, and her accent stemmed or came from her nationality, as she was, of Jewish origin, and she was a Brazilian as well. So it was held that the comments that were passed did amount to harassment. So that is the nugget for this week. Thank you.
Thank you so much, Lawyer Annie. And so we have it for our nuggets. Very soon we'll be looking at our main topic for today, and we will put out our questions for the nugget later on during the program. Please share and like the program. We'll be looking at our topic for today. If um, we can look, it says, how do I regularize my stay having lived in the UK illegally for 20 years? So how can a person who has lived here in the UK without immigration status, without any form of stay in the UK, now go ahead and regularize their stay? And in most cases, such people may have resided here. Some may not necessarily have had the right documentation to work, and so they would have probably used other people's documentation to try and work. But as much as possible, one way or the other, they may have had family, friends, attended church or associations with other people, and therefore that would have given them some leeway to be able to continue to live here in the UK without their immigration status. And so I would now ask our guest, Annie Akofio-Sowa, to take us through the topic for today, and then we will ask our questions and then move on with the program.
Thank you very much, Lawyer Eunice. So, yes, the topic for today is how do I regularize my stay having lived illegally in the UK for 20 years? So, before we even delve into the topic, I think it's important to establish what private life means. So, when we say that someone is applying for private life, what does that mean? So, someone can apply for private life or submit a private life application if they have lived in the UK for a substantial amount of time. So when they're submitting that application, they're basically saying that they have formed some type of ties to the UK, and they have severed any ties that they have to their country where they are originally from. So the relevant legislation that you'd look at is Appendix Private Life, and under that appendix there are three type of ways that you can apply for private life, or there are three types of people who can apply for private life. So number one, we have children who are under the age of 18 who have lived in the UK continuously for 7 years. That's number one. Or the second category of people who can apply for private life are young adults. So those who are over the age of 18, but they're under 25 years old. So let's say they're over 18. So between the age of 18 over 18 and 24 years old. And in that case, they would have had to have lived in the UK for at least more than half of their life. And then we also have adults who can submit a private life application if they have lived in the UK for more than 20 years, or in certain circumstances, they can also submit an application even if they have lived in the UK for less than 20 years. But that's only when there are significant obstacles that they would face in the country where they are from. So that is just an overview, and we'll go into a lot more detail. But in terms of the validity requirements that have to be met, when you're submitting an application, a private life application, you have to meet validity requirements, which are requirements that have to be met. And if you do not meet them, then your application will not be valid, which means that the caseworker will not even consider your application. They will not look at your application really. They will just reject your application because it's not valid to begin with. So one of the validity requirements is that you have to complete the correct form. As you know, there are so many forms online, too many online in relation to immigration. So you have to make sure that you fill out an application known as FLR, P, which can be found on the gov.uk website. So you have to make sure that you fill out that form in particular. The second requirement is that you'd have to pay the application fee, which includes so number one, you'd have to pay the application fee on the one hand, and then you'd have to pay also the IHS fee, which is in relation to the NHS charges. Then you'd have to make sure that you attend your biometric appointment, whereby your fingerprints will be taken and they will take a picture of you. It's important that you attend to your biometric appointment, because if you do not, your application will be rejected. Normally you have 45 days within. So if you submit your application, let's say today, you'd have to attend a biometric appointment within the next 45 days. Otherwise your application would be rejected. And lastly, you have to provide some type of national identity document. So normally we request for a passport copy just to confirm your identity, number one, and also your nationality. Then we have suitability requirements, which also have to be met. So when a caseworker is considering such an application, they will basically ask themselves whether the applicant's presence in the UK is conducive to the public good. So they would ideally, the applicant, of course, shouldn't be in detention. They shouldn't, have uh, lied in any previous applications, which is known as false representation, and they shouldn't also have been sentenced to imprisonment for more than 4 years. So if you meet the validity requirements and the suitability requirements, then at least the caseworker will now consider your application, your private life application. So in terms of the eligibility requirements, as I mentioned earlier, children can submit private life applications. So when it comes to that, they have to prove that the child has been in the UK continuously for 7 years. So let's say the child was born in the UK. That means that they would have lived in the UK from the age of 0. Let's say the child is now 8. They would have lived in the UK from the age 0 to 8. So that's good, because they have lived continuously in the UK. And then there is a reasonability or a reasonableness test that has to be met as well. So the caseworker would consider whether it would be reasonable to expect that child to leave the UK. And it's kind of like a balancing exercise. So the caseworker would consider different factors. They would consider the age of the child, how long the child has lived in the UK, whether the child has any family members in the UK, any friends in the UK. Of course, if the child has lived here continuously for 7 years, then they're going to school, they're going maybe to church, or they go to after school clubs. So they would have formed some type of ties to the UK. And the caseworker would also consider whether the child has any type of ties to the country where they might potentially be sent to, or whether they have visited that country before. So that is in relation to private life applications for children and what caseworkers would take into consideration. And then, as I said, there's also provision for young adults. So young adults can also submit private life applications if they are over the age of 18 and under the age of 25, and they have continuously lived in the UK. So the requirement that has to be met is known as the half-life test. So they have to make sure that, let's say the applicant is 24 years old, then they have to show that they have lived in the UK continuously for at least half of their life. So if they are 24 years old, they must have lived here, let's say from the age of 0 to 12. So they must have lived here for half of their life. But today, mainly, we're going to look at private life applications for adults, which specifically can be found in Appendix Private Life PL5. And basically, as I said earlier, adults can apply or submit an application if they have lived in the UK for more than 20 years. So in that case, they would have to show that they have continuously lived in the UK. Like, that is a very important requirement which has to be met. So someone might ask, what does continuous residence look like? What happens if I was detained at some point, or I was imprisoned? Would that break my continuous residence? So the casework guidance basically sets out that if someone is imprisoned or during those 20 years, or they were detained at some point during those 20 years, that wouldn't break continuous residence, as the applicant would still be in the UK. However, the time that they were imprisoned wouldn't count towards continuous residence. So let's say an applicant has been in the UK for 20 years. Let's say they entered the UK in 2005, on the 1st of January 2005, but they were in prison for 3 years, let's say, at some point. The 3 years, although it wouldn't break continuous residence, it wouldn't count towards the 20 years, which means that the applicant would have just been, for the sake of this type of application, they would have been in the UK for 17 years. And in that case, they wouldn't meet the requirement of having been in the UK for 20 years. So that is something very important to note. So time spent in prison and detention doesn't break continuous residence. However, it doesn't count towards the 20 years when you are making the when you are calculating it. So what breaks continuous residence? If the applicant has been out of the UK for more than 6 months at once, that would break continuous residence. Many people, they like to go to warmer places, warmer countries, especially when it's winter time, to at least not be too cold. But if you or the applicant was out of the UK for more than 6 months at a time during those 20 years, that would break the continuous residence, which means that when you come back, you'd kind of have to start afresh. Or even if you were out of the UK in total during the 20 years, you were out of the UK for 550 days, that too would break continuous residence. Or even if you were at some point removed from the UK, you were deported, that would break continuous residence as well. So that is very important to note. In terms of the evidence, when it comes to showing that you have lived in the UK for 20 years, most of our clients are quite concerned when it comes to providing evidence, because the evidence that they tend to have is in relation to their employment. But their concern is that at the time when they were working, they didn't have leave to remain. They were not technically allowed to work, and so they're concerned that if they disclose those documents to us, they can kind of implement themselves. But we always tell them that that is not the case. And the case of Mahmoud 2020 basically establishes this or supports this notion, because in that case, the claimant, essentially, he was from Bangladesh, and he used someone else's name, someone else's documents to work. So he was, let's say, known as person A, who was a British citizen, although that wasn't him. But when he appealed against the decision, the court held that he was still able to rely on that evidence, because honestly, what the court or what the caseworker would be looking at is not whether you worked in the UK or not. What they are interested in knowing is whether you have evidence to prove that you were resident in the UK. So you are able to provide payslips, any official documents that just have your name on there and are dated, is all that you would need in terms of evidence. It doesn't really matter too much how you obtain those documents. I mean, as long as those documents are genuine, that is a very important disclaimer. As long as those documents are genuine, that's all that really matters. So if you worked during the 20 years, that's okay. You can provide your pay slips, you know, your employment letter, any P60s, P45, honestly, anything, any official document that just has your name and is dated. Of course, you wouldn't have pay slips if you were not in the UK. So having pay slips would help your case, or even if you created or opened a bank account at some point, you could rely on your bank statements. You just have to make sure that the transactions within the bank statement shows that you were in the UK, because you can use your card, of course, outside of the UK. So the caseworker would go through your bank statement. So do make sure that the transactions in there show that you were, making transactions in the UK. You can also rely even on pictures. So pictures that were taken like back in the day, like on digital cameras, they would like digitally write on there the year or the dates that the picture was taken and the location. So you could rely on that as well. The Home Office wouldn't really accept or consider too much any pictures that you have provided. And if you have just handwritten on there, let's say Reading, UK, 1st January 2005. So if it is like that the camera wrote that there, then they would place, it would basically suffice. And if registered with a GP when you entered the UK, you can rely on that too, especially your medical history. You can request for that. You can either print it from the NHS app if you have access to that, or you can go to your GP and request for that. Because if you have printed your medical history, and of course, in your medical history, it will state every time that you attended a GP appointment, or every time you went to the hospital. So that will show that you were in the UK. For example, if you went to an appointment at some point, it will say that you attended this appointment at this date and this doctor attended to you. So relying on that, I mean, it will be very helpful to rely on that if you have access to that, or even if you have a tenancy agreement, any utility bills, honestly, any type of document that you have that is official, that is dated and has your name on there, you can rely on that document to show that you have had continuous residence in the UK for at least 20 years. Lawyer Eunice, before I continue, I think I will let you come in. Lawyer Eunice, you're muted. Lawyer Eunice, you're muted. Hello, Lawyer Eunice. Hello, Lawyer Eunice. You're muted.
Can you hear me? Can you hear me?
Okay.
Okay. So thank you so much, Lawyer Annie, for that very detailed um matter into our 20-year leave to remain private life application. And I know that there will be viewers watching us now who may know other people who are in this situation and would want to make an application. And before we open the telephone lines, I know that there are people who are itching to ask their questions. Also, there will be a chance for us to answer those questions. I'll just briefly mention the numbers that we'll be using for the program, and then you can we'll go ahead and ask any questions. So the numbers that we'll be using today are 0208 493 7345. So 0208 493 7345, and then the mobile number is 073 9920 8468. So 073 9920 8468. Yes, Annie, you were mentioning something in regards to the fact that when somebody has lived in the UK for a period of 20 years, it's more likely than not that some of them may have used other people's documentation whilst working here in the UK. And it might be that for some reason they were not working for some time, or they only started working, let's say, 10 years ago. What do they do if they haven't got evidence for certain periods in time? So I came to the UK, I lived with a friend for 4 years. I never really thought I could register with a GP. Later on, someone said to me, "Oh, I can give you my documentation and you can work with that." And I worked with that for the rest of the period that I lived in the UK. I don't really know if I will be able to provide anything for the 4 years that I was living with a friend. Can I still apply?
Yes, the person would be able to apply. So, in that case, if the person doesn't have any evidence for a period, as you said, using the example, if the applicant was living with a friend, in that case, we would normally request for a letter from that friend to confirm that indeed they knew that person during that period. We ask for letters from friends or even church or mosque if the person goes to mosque. But what is important to note is that the Home Office doesn't place a lot of reliance on these type of documents because anyone can really write those letters. Like if you ask a friend to write a letter for you to help you with your immigration application, of course, what they would write would be favorable, and the Home Office understands that that can happen. So although we would request for some type of letter to cover that period, the Home Office would consider that evidence, but they might not place a lot of reliance on that evidence.
Okay. And I know you also mentioned that when it comes to continuous residence, there are certain years that you may not be able to count towards the 20 years. So, if for instance, let's say that I committed an offense and literally I was in prison for 9 months. Um, and this was sometime, let's say, in 2012. Does that mean that um the year 2012 will be the only year that will not count towards my 20 years, or does it mean that I'll have to start counting from 2013?
Thank you for your question, Lawyer Eunice. So it's just the period that the person was in prison for that wouldn't count towards the continuous residence. So if the person was in prison in 2012 for 9 months, is those 9 months that wouldn't count towards the continuous residence. So let's say the person was imprisoned in January and they were in prison until September, is that period that wouldn't count towards the calculation. However, from September going, when the person was, released from prison, that would count towards the 20 years in the UK.
Okay, okay. Thank you so much, Lawyer Annie. We'll go on a short break, and then when we come back, we will now open the lines for our viewers to also ask their questions.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay, thank you once again for joining us on the community and the law. The numbers to call are 0208 493 7345 and 073 9920 8468. So before we go on with the questions, our nuggets for this week. Let's look at the nuggets for this week. So it says any comments about your accent may amount to harassment, and the courts have said that in some cases harassment may occur when the harasser is not motivated by the protected characteristic as defined by law. This breach of the law may happen if the comments are unwanted and reasonably have the purpose or effect of violating dignity, then they can amount to harassment. Sorry. The fact that the comments made were not motivated by the claimant's race did not prevent them from amounting to harassment if the other parts of the definition of harassment were also met. And for our quiz question, we have Mercy Frimpong, a Ghanaian national, brought a claim against her employers, claiming that she had been harassed due to unwanted conduct related to her race by way of comments made about her accent. She was working in her employer's customer service department. Her manager had told her that her strong accent was difficult to understand, and this was an issue when your role is one of communication, engagement, and partnership. What is likely to be the outcome? I smile because I can just imagine somebody just saying this out loud, and the fury that can be, I mean, reciprocated to such a statement. Let's look at the questions. It says that what is likely to be the outcome? A. As a customer service specialist, she must be able to communicate so the manager's comment is not harassment. B. If such comments relate to a protected characteristic of race, they are reasonably considered to have the purpose of amounting to harassment. And C. She is only playing the race card and it will fail. So I will leave that question to our viewers and we will see how many of us come up with the right answer. Just before we take your answers, Annie, in relation to the topic that we had for today, we spoke about three categories of people who could apply under the private life route, and that were the children um, who I would say were born in this country and have lived in the UK for a continuous period of 7 years. And you also spoke about those that are young adults who are between the ages of 18 to 24 and have lived here more than half their life. And then you spoke about adults who have lived here for a period of 20 years and are basically making an application based on their private life. How about adults who have lived here for less than 20 years? Can they or would they be able to make a successful application under the private life route?
Thank you, Laura, for your question. So, yes, people who have lived here even for less than 20 years, they can submit a successful private life application if they can show that they would face very serious obstacles if they were required to return to their country. So, for example, if a person can show that they would face death potentially, um, if they can argue that, then they would be able, or their application would or can be successful. So to provide an example, if an applicant, let's say, is here in the UK and they have lived here for less than 20 years and they are unwell, seriously unwell, and they are receiving medical treatment, they are constantly being reviewed, the applicant can argue that if they were required to return to their country, let's say Ghana, that they could potentially, I mean, it wouldn't help them because the level of support that they're receiving here in the UK medically, they might not be able to receive that in Ghana, or even if the person is experiencing any type of mental health problems, they can rely on that to, let's say the person has been diagnosed with depression and they are receiving help, they're receiving counseling, they are on antidepressants, they can rely on that too. Or even if the applicant is, let's say, a homosexual and they are from a country where that is totally illegal, they can rely on that to basically say that if they were required to return to their country where they are from, they can potentially face persecution in that country. But of course, as with all things, it's not just by word of mouth. So they would have to provide evidence. So let's say that the person is here as they're homosexual, they would have to if they can provide evidence that they have been receiving threats from people in their country, whether it's, let's say, on Facebook or on WhatsApp, if they're receiving any type of messages stating that if they come back to that country, they will be in serious trouble, the applicant can rely on that. Or even if the person is critically unwell, like seriously critically unwell, they can request for a letter from their GP, which would support the application that is best for the applicant to remain here in the UK, and that is honestly in their best interest, and that it would the treatment that they're receiving here has to be completed before anything bad can happen. So, yes, someone who has lived in the UK for less than 20 years can submit a successful private life application, but it's just about evidence and whether they're able to provide evidence to show that they would face significant obstacles in their country of return.
Thank you so much, Lawyer Annie. I believe that anybody listening to this will have some answers to give to any person who wants to apply under this route. And so, without much ado, I think there are questions that we have that people have asked for us to answer. This is from Lydia Opon. She says, "What can I do if I do not have enough money to pay for my private life application?" So, what do I do if I do not have enough money to pay for my private life application?
All right. Yes. So it's a very good question because private life applications are quite expensive. I believe the fee is just over £3,800. So of course, not everyone might be in the position to, pay for the application. So if you are not able to pay for the application, you can consider submitting a fee waiver application. If that type of application is granted, then the application, you wouldn't have to pay for the private life application at all. So as part of the fee waiver application, you'd have to show that you are either destitute or at imminent risk of destitution, which means that you either do not live in adequate accommodation, or you do not have enough money to meet your essential living needs. So, for example, you don't have enough money to pay for food, clothing, or even if you have any children or the applicant has any children, then you can rely on that too to argue that if I pay for this private life application, then that would prevent me from meeting my child's essential living needs because I've basically spent all my money, I've spent all my savings. So, as part of this application, you'd have to complete a fee waiver application, you'd have to provide your bank statements. Normally, we request for 6 months worth of bank statements, and you'd have to annotate transactions over £250, which are outgoing. So you'd have to explain like what the purpose of that transaction was, and there's also a section where you would have to list all your income. So if you are working, you'd have to provide your pay slips, your P60s, your employment letter to show how much you earn. So you show how much you earn, and then you also show your expenses. And if your expenses are a lot, which means that you do not have a lot of money left at the end of the month, then it is possible that your fee waiver application can be successful. And in that case, you would be able to basically submit a free private life application.
Very, very detailed answer to her question, and I believe that Lydia has received her answer. Mr. Benjamin Osei says, "What can I do if my private life application is refused?" So, what do I do if my private life application is refused? Yes, Annie.
Yes, so if your private life application is refused because let's say you were not able to provide sufficient evidence that you have continuously lived in the UK for 20 years. Let's say there are some years that you were not able to provide evidence for, your application can be refused. And in that case, you can appeal against the decision. So that's actually a service that we, provide. You would appeal against the decision. You would have to pay the court's fee, which is £140. And well, you can decide whether you want your appeal to be heard on papers or there should be an oral hearing. If you want the appeal to be heard on papers, you'd pay £80. So in that case, we would put together the bundle of evidence to show that the Home Office basically made a mistake in their decision. And then the bundle would be presented to the judge, and they will then consider the bundle and make a decision. Or you can pay £140 and you'd go to an oral hearing. So, of course, we would still put the bundle together, write witness statements, request for further evidence from you, and you would go to court with a barrister, and the Home Office legal representative would be there as well, and you'd be making like representations in court, and the judge will then decide based on everything and whole, the evidence and whole that has been presented to them, whether your appeal should be successful or not. So private life applications can definitely, if it doesn't go well, there are options available.
Okay. I think that he's also received his answer. As she said, you will have a right of appeal in regards to your human rights private life application. And once you have appealed, you can obviously present documentations that previously were not there. The court has discretion to also regard any evidence that was not before the Home Office per se. We have Mr. Kobna Easy. He says, I was on the 10-year route to settlement on the parent route based on my two British children. I have now completed the 10 years and I would like to apply for indefinite leave to remain. Which form do I fill out? And what documents do I need to provide? Okay, Lawyer Annie.
So you would fill out a form known as Set LR, and as part of that application, you would have to prove that you have been lawfully resident in the UK for 10 years. So it looks like from your question that you were put on the parent route, on the 10-year route. So you'd have to prove that you were in the UK legally for 10 years. So if you have your previous BRP cards that were issued to you, or if you have copies of those, that would help. And then any evidence to show that you were in the UK during that time, you would have to provide that as well. So you could provide bank statements, pay slips, P60s, GP letters, just any type of letter that shows that you were a resident in the UK for the 10 years. And then you'd also have to sit and pass the Life in the UK test. So we would request for the certificate, or if you have a reference then number, then you can give that to us as well. Or you would also have then to sit the English language test at level B1. And if your children, your two British children, reside with your partner or your ex-partner, then we would normally request for a letter from them to confirm that you still continue to play a role in your children's life.
Okay, thank you so much. And I believe Mr. Kobna Easy has his answer. Um, I know that there was a question as well from Mr. Daniel Apia. He says, hello, BWF team. My question is to do with EU nationals with settled status who have to apply for an e-visa. Or I think the question is, do they have to apply for an e-visa? Yeah.
Thank you, Mr. Apia, for your question. So, if you are an EU national, you do not have to apply for an e-visa. So, the e-visa is for those who are basically not EU nationals, or they are not dependent of EU nationals. So, if you look at your card that was issued to you, if it says by residence card at the top of your card, then no, you wouldn't have to apply for an e-visa because you would have a UKVI account. So the e-visa is just for those who have a residence permit. So at the top, if it says residence permit, in that case, you would have to create an e-visa. Otherwise, you do not, because with a UKVI account, your status already is online. Yeah.
Thank you so much, Lawyer Annie. I believe that he also has his answer. Okay, I know that there are people who have also answered our quiz questions as well. I believe that there are no calls that have come through as yet, and I see some questions on our comment section. Um, Nana Etiahene, he says, please, on validity of application, does applicant need to upload a copy of application form, scanned copy of email as evidence of IHS payments, scanned copies of email or printout receipts from the website, and evidence of appointment booking, including the barcode? Lawyer Annie, would the person have to upload these evidence as proof of validity of application and submit them as evidence that they have made a valid application?
Hello. Yeah. Thank you for your question. So no, please, you wouldn't have to upload those basically to make the application valid.
Yeah, so I think the application form would have already been sent to them, so they don't need another copy of the application form. And they will definitely not need an email because the email will be sent from their third party contact, which is TLS. So they wouldn't need an email copy of IHS payment as well because that is coming directly from the Home Office. So they wouldn't need any of that as they are the ones who will be sending you the receipts in the first place. Okay, so Mr. Saba Saba says, please, overstayer has applied for leave based on her British child. Application is submitted, but their email directs her to UKVI website to upload documents and book appointments at UKVI Support and Services Center. Why not commercial partners but home office? And providing biometrics at home office is uncomfortable. So advice please that there will be no discussion. I believe he's trying to say that there will be no discussion about her circumstances. Is this an interview to prepare for? And they will keep her passport until decision. Why, please? So, Mr. Saba Saba, most human rights applications would usually have the biometrics center or the biometrics taken by the UKVI support center and not the commercial partner such as TLS Contact because it's usually a human rights application for the first two and a half, for instance. They would do it at their support center. There is no interview at the support center. Usually, when you go, they would just take your passport, they would retain it if you are an overstayer or if you're applying for the first 2.5 years. They would usually retain your passport because they have the right to do so under the Immigration Act of 1971. And there is no interview whatsoever, so you don't need to prepare for an interview. They would just take the passport and take your fingerprints and your photograph. Is not intimidating. They try as much as possible to make sure that they have the right information, and if the documentations that they have is not sufficient, they would email you to let you know that they need further documentation as well. It is not to intimidate the applicants, it is just so that they have enough information or documents to make their decision. And so, once a decision is made, or once you are successful with your application, they will return the passport to you. Um, that is usual for most human rights applications that are being made for the first time or where the person has overstayed. Yeah.
Eunice, I
I
think there's someone on the phone.
Oh, okay. If we have somebody on the line, please go ahead with your question.
Hello, can you hear me?
Yes.
Oh, good evening to you all. My name is KK, and Happy New Year. My question is, I want to find out if there's a specific law or act in the immigration, a specific act in the immigration uh, law, okay, that specifies, for example, if you are on the spousal route, which is a family route, like 2.5, and you stay outside the country, it's more than 3 months within a year or 6 months within a year. Or let's say, for example, if you've been granted indefinite leave under the immigration rule and you live outside the country over 6 months, then they say you've lost that. So if you want to come back, then you have to apply as a returning resident or something like that. So if you have any problem, for example, if they, then you will be at the mercy of of the case handlers to, I mean, if you meet the condition under which you are applying before they will grant it again. I want to find out if, let's say, they refuse you, and if there isn't any specific act, immigration act, that specify the amount of time you can live outside the country and you lose that right, and then it's only stated in the immigration rule, then can you also fall on the law, on the act itself, to say that there's no act that specifies that. It's just the rule. And if the act doesn't specify, which is heavier than the rule, then you rely on that. Thank you.
Okay, so if I have your question correct, you are asking if there is any primary legislation that states that a person who has indefinite leave to remain should not remain outside of the UK for 2 years or more. Is that correct?
Yes,
Sorry, did you
correct.
did you hear the
Under the immigration
yes,
rule.
I rephrased it into a short one, so I hope I
Yes,
got your
that's correct.
question. Okay. So when it comes to any person who has indefinite leave to remain in the United Kingdom, yes, we have our immigration rules, but also we are governed by the Immigration Act of 1971. We are also governed by our Immigration Act of 2014 and 2016, and the Nationality and Immigration Act and Asylum Act of 2022. And then we have other immigration acts as well. So when it comes to those who have indefinite leave to remain, usually as immigration lawyers, we will look to the immigration rules. I know obviously when it comes to the immigration rules, most of it is by the Home Office Secretary in regards to how she will regulate um, those who are coming in and out of the United Kingdom. And it states clearly what a continuous residence is, and somebody who obviously has come to live in the UK, has settlements, and has decided to leave the UK will tend to lose their right to settlement having lived here for more having lived outside the UK for more than 2 years if they have indefinite leave to remain based on the immigration rules. Those under the EU settlement scheme are allowed to live here, I mean, outside for more than 5 years. So, I mean, they can live outside for 5 years, but not more than 5 years. So, when it comes to any um, settled person, most likely than not, you'll be looking at the immigration rules. And then the bedrock of our immigration rules stem from the Immigration Act of 1971. So anything to do with leave to remain, leave to enter, settlement, it all derives from the Act of 1971. Yeah?
Oh, okay. So there is something in the act that specify that.
Yes. There would definitely be. Yeah. I don't know the specific section, but most of the immigration rules stem from some act that we have under our immigration law.
Right. Okay. Thank you.
You're welcome. Okay, so to our um, viewers, I know that we have given you much time to answer our quiz questions. So very soon we'll be going to our quiz questions to see what answers you have given us. Nana Jaman says, please, lawyer, I want to go and bring my wife to the UK, but I don't have the 29,000 annual income per annum. What should I do? So this is somebody who has decided that they want to bring their spouse, but they are not earning the 29,000 per annum. Most of the time, if your income is not meeting the threshold, we would usually advise that you go for more hours or you go for a second job. So if you go for more hours or a second job, it is more likely than not that you'll be able to meet the 29,000 per annum threshold. Where, for instance, there are human right claims. So, for instance, you are saying that because of a child or children that you are looking after, and therefore, even if you tried to meet the threshold of 29,000 per annum, you still wouldn't be able to meet those requirements. The caseworker may look at exceptional circumstances. And so, under our immigration rules and Appendix FM, we have exceptional circumstances, and the caseworker will be looking to see whether it will also be exceptionally difficult for you to work those hours to earn that amount of money to bring your wife into the UK. Under Gen 3.1 of the immigration rules, where the financial threshold has not been met and there is a human rights claim, the caseworker is to look at whether it will be unduly harsh for them to refuse your application based on the fact that you are not able to meet the financial threshold. In those circumstances, it is said that you can show that you have third party financial support. So it may be that a third party, such as a family member, has enough bank balance on their bank statements to show that they will be able to support your wife when she comes to live with you. Or it may also be that your wife is guaranteed employment, and so there is a letter from the employer to state that once she comes, she will be working and earning the 29,000 per annum amount as stated as well. Or maybe she may also be able to show that she has enough savings to be able to overcome that 29,000 per annum threshold. So it's important that if there is a human rights claim, you also look at Gen 3.1, and most caseworkers will also look at the reasonableness test in Gen 3.2 as well to say if it is unduly harsh to refuse the application because it will be extremely difficult or harsh for you and the child and your wife who will be coming to the UK. And Mr. Ibrahim Munkalia says, under the private life, whilst do I have to support work whilst submitting application and wait for decision? Do I need a fresh passport as part of the application process? I believe he's trying to ask, under the private life route, do I need to add any support work I've been doing during those years when submitting the application? Um, Annie, is it possible for him to add any support work he has been doing before he submits the application? And does he have to make the application with a fresh passport, um, or he can use the expired passports that he has? Yeah.
Yes, so in terms of the first question, if I'm not misunderstanding it, you're asking if you can rely on your work to show that you've been resident continuously in the UK for the private
I
life.
believe so. I believe that's what he's trying to say.
Oh, okay, okay. If that's the case, then yes, you can rely on your evidence from work. So you can rely on your pay slips, your P60s, your employment contract or letter. You definitely can because it would show that you're resident in the UK. And then in terms of the second question, you need to, as part of the application, provide a valid passport. So if your current passport has expired, we would advise that you renew your passport so that the application will be valid. Because if you submit an application with a passport that is not valid or has expired rather, then the application will not be valid. So please do renew your passport.
Thank you, Lawyer Annie. So let's go to our nuggets for the week, and then we look at the question and the answers. So it says comments about your accent may amount to harassment. The courts have said that in some cases harassment may occur when the harasser is not motivated by the protected characteristic as defined by law. This breach of the law may happen if the comments are unwanted and reasonably have the purpose or effect of violating dignity. Then they can amount to harassment. The fact that the comments made were not motivated by the claimant's race did not prevent them from amounting to harassment if the other parts of the definition of harassment were also met, as in the case of E. Carosi and the University of Hertfordshire, Miss A. Lucas, 2024. I believe that our question has been understood. It says that Miss Mercy Frimpong, a Ghanaian national, brought a claim against her employers, claiming that she had been harassed due to unwanted conduct related to her race by way of comments made about her accent. She was working in her employer's customer service department, and her manager had told her that her strong accent was difficult to understand, and this was an issue when her role was one of communication, engagement, and partnership. Now to the questions. What is likely to be the outcome? As A, as A, as Miss Mercy Frimpong is a customer service specialist, she must be able to communicate so that the manager's comments is not harassment. Okay, so that's for A. B. If such comments relate to a protected characteristic of race, they are reasonably considered to have the purpose of amounting to harassment. And then C, she is only playing the race card and therefore it will fail. I would like to see how many people came up with the right answer. David Alote says A. Thank you so much, David, for joining the program. And then Kindly, thank you so much, Kindly. Kindly says B. Okay. And then we have Mary Adai. Thank you so much, Mary, for joining the program. Mary says B. Okay. And then we have Ajwa Ngum. Thank you so much for joining the program. Ajwa says A. Okay. And we have Emanuela AJ. Thank you so much, Emanuela, for joining the program. Emanuela also says A. Okay. Okay. Lydia Opoku, thank you so much for the question as well. Lydia also says A. A lot of people going for A. We have Nana Bwedu. Thank you so much, Nana Bwedu, for joining the program. He also says B. B. Okay, and then we have Abna Fosu. Abna Fosu, thank you so much for joining the program. She says the answer is A. So the answer is A. And then we have Daniel Apia. Thank you so much for joining the program. He also says B. And then we have Kwabna Yame. Kwabna Yame, thank you so much for joining the program. He says the answer is C. Okay, so it seems like the A is really going forward. We have Kofi Dankwa. Kofi Dankwa says the answer is number 2. Thank you so much, Kofi Dankwa, for joining the program. Okay. Sorry about that. And so, to the answers of the quiz questions, I know that a lot of people have said A. There have been some that have said B, and one for C. Mr. Edu Buahin says the answer is B. Thank you, Mr. Edu Buahin, for joining the program. And Mr. Kwejo Tufo says the answer is B. Thank you so much for joining the program, Mr. Kwejo Tufo. So I believe that we have our answer to the question. Lawyer Annie, please take us through.
Yes, thank you, Lawyer Eunice, and thank you to all our viewers who have participated today. So, looking at this scenario, it's very similar to the case of E. Kabrozi, because in this case, Mercy Frempong, first of all, is a Ghanaian national, and she has had comments being made from her manager concerning her strong accent and that it's difficult to understand. So the facts are quite similar. So she has brought a claim for harassment, and the question is, what is the likely outcome going to be? And those of you who said B, that is the correct answer. So B says, if such comments relate to a protected characteristic of a race, they are reasonably considered to have the purpose or amounting to harassment. So in this case, the conduct of her employer amounts to potentially harassment because the comments are unwanted, number one. Number two, they are in relation to a protected characteristic, namely race, because her accent basically stems or is a result of her nationality. And thirdly, the result of the comment, although it might not necessarily be its purpose, but the result of the comments is that it violates B's dignity or it creates a hostile environment for her. So the answer definitely is B. Thank you all to you all who have participated. So as you can see on the screen, it says the answer to this week's test, your knowledge is 2, so that is B. And it says in some cases harassment may occur when the harasser is not motivated by the protected characteristic, while mention of a person's accent would not always amount to harassment. Such comments may be related to the protected characteristic of a race. And if the comments are unwanted and reasonably have the purpose or effect of violating dignity, then they can amount to harassment. So looking at this, it's not really, the court wouldn't consider what the person's or the manager's intent was or what the purpose was of saying that. It's more of the effect. And in this case, it would have the effect of violating Mercy's Frimpong's dignity. So yeah, that's the answer for today. Lawyer Eunice, you're muted.
About that. Thank you so much, Lawyer Annie, for taking us through the answers. I know some people are very excited that they had it correct. I can see on our comment section that they are very happy that they got the right answer. Kwejo Tufa is very excited. He says, "Yay, I said B." And I I send me a t-shirt. Mr. Kwejo, when we do make some more prints, we will send you one. If you send us your details, when we make some more prints, we will send you a t-shirt. So yes, there are people that are very excited that they got the correct answer. It wasn't very easy. I know that it seemed a bit technical, but well done to all the people that took part in the quiz, and especially well done to those who chose B or number 2 as their outcome to the question that was posed. Thank you so much. And so, without wasting much time, I know that there are people who are wanting to ask more and more questions. Our time is almost up. We wouldn't have time to go through all the questions that are coming up now. And I believe that you have enjoyed the community and the law. I would like to say that as much as possible, do go on our Facebook page and our website. We have more information there. And if for any reason you feel that you need to book an appointment to come and see us, or you need to book a consultation remotely, do not hesitate to contact us. Our telephone number is 0208 493 7340. So it's 0208 493 7340. We are opened from Monday to Friday from 9:30 a.m. to 6 p.m. every Monday to Friday. And if you wish to come into our offices, because obviously you will want to see us face to face, we are situated in Seven Sisters. Our address is the fourth floor of Anna House. So the fourth floor of Anna House. 214 to 218 Tottenham High Road. And the postcode is N154NP. So N154NP. Do give us a call and we will make sure that we will give you the best possible outcome necessary for your case. Very quickly, I'll ask Lawyer Annie if she has any last words before we end the program.
Yes, viewers and listeners, thank you for staying with us until the end. So today we have learned that it is very possible to regularize your stay in the UK, even if you have lived here illegally and for 20 years. It's very much possible. All that you have to make sure is that you have evidence to prove that you have been here for 20 years. So any official document that has been addressed to you that bears your name and is dated, you can rely on that. And even if you submit the application and it's refused, you can still appeal against the decision. So that's good news. So thank you all for joining us today, the community and the law. Thank you.
Thank you once again to Lawyer Annie, and thank you once again to our viewers watching us right from wherever you are. We are grateful for your viewership and your support. And hopefully next week we will have Mr. Kweku Frimpong hosting the program. Thank you for your support, and we'll see you again next week.